Agency law is what we're moving on to, okay? And chapters 29 and 30, the concepts of agency law really build on contract law, they build on tort law, and employment law, which we're going to cover right after the midterm. So these concepts are very, very, very interconnected. So these are not exactly standalone chapters. They really are giving us a terminology that we will need as we sort of go forward as we cover different other areas of the law. So remember we talked a little bit, I think, when we were talking about negotiable instruments about this concept of principal and agents, right? The legal notion that somebody else could be appointed to act for a principal, right? Sure. Use of agent allows one person to act on behalf of another. I want to say person, but think about person as being broader than an individual. You know, it could be an entity. It could be a business, right? And we know that that makes perfect sense. We have to give legal rights to people to act on behalf of other businesses, other people. We just need to figure out what the liability and how that is all structured. Yes? You should be. Right. Okay, the question is an excellent one. And the question is, well, I'm confused. When is an agent an employee? Is an employee always an agent? You know, are these synonymous? And the answer is, wait, that's what we want to work through a little bit. The answer is not black or white. The answer is, let's first understand what an agency is. The short answer is, an employee can be an agent, but doesn't always have to be an agent. Okay, so let that sort of percolate, and then let's talk about it a little bit. And let me make it a little bit even more complicated. So you have agent employees. You also have these folks or entities called independent contractors, right? What are independent contractors? Someone who is hired by a principal to do something for them, but on a limited basis. Okay, so let's have that concept out there as well, and we'll talk and differentiate between them. All right, let's first understand what a principal-agent relationship is all about. This relationship is a fiduciary relationship, and the word fiduciary, we always try to define it. We know what it means, right? A fiduciary is someone who owes a legal duty, almost of loyalty, someone of trust, right? A fiduciary relationship which results from the manifestation of consent by one person to another that the other shall act in his behalf and subject to his control and consent by the other to so act. Oh my, that's a definition, all right. It simply means that a relationship between a principal and an agent is one of trust, and one, legally speaking, is only valid when the agent is acting lawfully based on what the principal wants them to do or not do. Okay? All right, we'll play this all out. So what is agency law? Like anytime we go into a new area of the law, we says what law governs, where does it come from, so on and so forth. Well, agency law is a body of common law that governs agency. And what does common law mean again? General, but where does it come from? What kind of law? Something that Congress enacts or something that a court? Yeah, it's common law. Every time you hear the word common law, think about precedent, court precedent. Not necessarily, for example, state statutes, right? The Uniform Commercial Code is not common law. Uniform Commercial Code is a statute. It's the legislative branch has enacted it. So when we think about agency law, for the most part, it's based on precedent, right? And it's a mixture of contract law and tort law. Okay? So all of these concepts of negligence and contract law that everyone said they've taken business law 1 are going to come back in some ways when we talk about principal agent. And the reason they're going to come back are the duties that principal and agents owe to one another, and they owe to third parties. right? We always say in the law, we learn the basics and we learn about things that go wrong, right? The liability part of it. And that really is what's so significant about understanding what the source of the law is. So just like bankruptcy law is federal law, agency law is not federal law. It's really state law, a mixture of common law based on contract and tort principles. Who is a principal? A principal is a party, individual, business, whatever the case might be, who, and I know employs, right? You're already struggling with, does it have to be an employee, does it not? Wait, we'll get there. Someone who hires someone to act on their behalf, okay? That's a principal. An agent is someone who agrees to act for another. So remember I said an agent doesn't always have to be an employee, right? For example, we said that the bank-customer relationship is principal and agent, right? There's no employment relationship there, is there? Right? The bank is acting as an agent, working for a customer, the depositor, to say, do this, but don't do that, under my checking account, for example, right? But that's not to say that employment cannot result in an agency as well, but how do I say this in a way that's understandable? A principal-agent relationship is not just an employment relationship. It can be much broader than that. But as we'll see, for our purposes, we will talk a lot about when is an employee an agent. When can an employee make their employer liable? Depends. Is that principal-agent relationship an employer-employee relationship? And was the employee acting as an agent of the principal? Sometimes, not always. We'll see when that happens. Principal, agent, third parties, right? For example, there is a contract between an agent and a principal, right? Maybe someone has hired somebody, a business has hired a real estate agent to go find them a piece of property. It's not an employment relationship. They've just entered into an agreement to do so. Based on that agency contract, the agent signs a real estate contract for purchase of a piece of property on behalf of the principal with the authority given to them. What have they done? They have basically, in executing a contract with a third party, made the principal liable to perform on that contract with that third party, right? They're not buying the property themselves. They're acting on behalf of their principal under the legal authority to do just that one thing, okay? Not an employment relationship, but still a principal-agent relationship. All right, a few more things to kind of set the stage. Who can be a principal? Who can be an agent? Well, for example, who can appoint an agent? Anyone, and now start thinking back to contract law, anyone that has the capacity to contract with somebody also has the capacity to have someone act on their behalf. And what do we mean by capacity? Understanding, and that could be an intellectual capacity. It could also be simply based on age. Simply knowing the law, basically saying you have the authority, the ability, rather, to appreciate what it is that you're doing. You may be making a good deal or a bad deal. That's not the law's business. What the legal notion of capacity is, do you understand? Did you have an understanding of what you're doing? And we say that someone with lower intellectual capacity under the law just simply doesn't, right, for example. So people that lack contractual capacity to make a contract also cannot appoint an agent because the law assumes that they do not have the understanding, the minimum level of understanding, to know what the legal consequences of that may be. Okay. Now let's talk a little bit about type of relationships, right? So first you have this broad category of principal and agent. Again, the agent has the authority to act on behalf of the principal as authorized by the principal and implied from the agency. What does that mean, implied from the agency? Does an agency relationship have to be in writing? If I'm appointing someone to do something for them, I'm giving them authority to do something. Do I always have to put them in writing? Not always. Can you contemplate that sometimes they might? Sure. For example, if I'm hiring somebody to find me a property. Real estate contracts are subject to statute of frauds. They have to be in writing, right? So it depends. It depends, but I'm only giving, if I hire somebody to find me a piece of property and it has to be in a certain location, it has to meet certain requirements, a certain price tag, well, understand that the agent's legal authority is bound by those requirements. Going beyond that is acting outside of our agency relationship, okay? Now, maybe to answer your question, an employee is often the agent of the employer. An employee is often, but not always, an agent of an employer. So what is an employer-employee relationship? An employee is hired to perform a task or service, right? So I could be hired by Radio Shack to work one of the cash registers, right? That is a employer-employee relationship. I'm going to get a W-2. I might even get some health benefits. I will, be treated like an employee. And we'll see that employment law is, has a whole bunch of rules and so on and so forth. The question is, am I an agent of Radio Shack? In my capacity as a, as a cash register clerk. What do you think? What is an agent? Am I acting on behalf of Radio Shack? Well, you might say yes, in dealing with their customers. But can I bind my principal to in any legal way? If someone comes by and says, you look like you're an employee of Radio Shack, can we sell you cleaning services for the store? Can I say, sure, yeah. No, I'm not an agent. I cannot enter into a contract. I mean, I could, but I've just done something for which Radio Shack is not responsible, right? So an employee usually cannot enter into contracts on behalf of an employer, but certain employees can if they've been designated with that authority, right? So this is where I come back and say that an employee is sometimes an agent, but not always. You have to see what the employee is hired to do. So a rank and file employee usually is not an agent. But, for example, if you have a business and you hire people to run a partnership and they're running the operations, they're making deals, that's an agent, right? But if you're hiring somebody to do bookkeeping and only bookkeeping, they're not an agent, they're just an employee. Yes? What about the purchases? Sure. That's right. So the question is, what about an employee that has the authority to make certain purchases, right? So remember, I was careful. I said I'm just checking out people, right? But if I am a assistant sales manager or something, and what I'm doing is saying, well, I have to buy inventory for the store. That's part of my responsibilities. I am both an employee and an agent because I can bind the principal because that's part of my job duties. So every employment relationship has to be looked at. So you're right, a rank and file lower level assistant manager could be an agent to a certain degree, right? But you really have to see, what is this person hired to do, right? Are they only an employee, or in some aspects can they bind their employer to certain things? And in your example, someone who's buying some stuff for the store because of their job responsibilities is an agent in that capacity, absolutely. Oh my goodness. So I have someone giving me an example. I don't know if that's, that's binding. I don't know if I would take that to an agent capacity. It starts to get fuzzy a little bit. Because you're involving a third party. And I might just say, I get my next month's bill and it's a higher amount. I say, but I spoke to customer service representative Jeanette on February 21st, and she promised me, 2 months of showtime for free or something like that. Yeah, in that limited capacity, they are binding the cable company. It's a gray sort of a thing. Yes, it is possible that certain employees, even at lower levels, could bind to some degree. But, I come back to, a worker on a factory line, a cash register, a Walmart employee, a Target, checkout. Not typically someone who's, binding their principal. Typically only an employer-employee relationship, not moving into that principal-agent relationship. But you got to look at each of these situations fact by fact by fact. Okay? All right. So we said we're going to throw another little monkey wrench, and that is the principal-independent contractor relationship. So the notion here is that the contractor is not an employee of the principal, but has been hired by the principal to do a certain task on behalf of the principal. Right? And this is where, and we talk a little bit more about this in the next chapter, the line gets a little bit fuzzy. Right? You hire an employee to do X, Y, and Z, and you tell them what to do. But you hire an independent contractor, you also want them to do something, but the notion is that there you have less control over how they do it. Like if I want somebody to come and work for me, right, I want them to open the store at 8 o'clock. I want them to close the store at 9 o'clock. I want them to receive customers. I want them to ring up purchases. That's an employee, right? But I want somebody to come in, a couple of times a week to make sure that my equipment is working okay. And it's an outside company that provides a service for a bunch of different stores. That company is not my employee. They're my independent contractor. Yes, I'm telling them what to do, and I'm going to pay them just like I pay my employee for what they're doing, but they're really being hired for a certain task, right? And again, that line gets blurry as well, but that really is more of a principal-independent contractor relationship. And generally speaking, a principal can authorize an independent contractor to enter into contracts, and principals will be bound by those contracts, but that's not always the case, right? So again, just like you have to look at an employer-employee relationship, depending on what it is that the employer is telling the employee to do or not do, independent contractors may or may not be agents of the principal. Depends on what they're doing. Depends on what they're doing. And the reason we keep sort of harping on this is there's liability, right? If someone is an agent acting in the name of the principal, they could potentially make the principal liable, even though the principal personally did not do something, right? So that's why it's so important to know, is it a relationship that is principal-agent, or is it not a relationship that is principal-agent? And we'll look at several examples, and we'll talk a lot more about this. This was sort of an interesting little case, wasn't it? This is a chili case, or the Chili's restaurant case back in 2005 out of Massachusetts. What happened? Let me see a show of hands, someone I may not have talked to today. Yes? Suffered injuries.
Yeah, so two of the people that got injured tried to sue Chili's.
The company.
Yeah.
Based on what?
Negligence.
Yeah. And they were trying to say that Chili's was basically right, and their agent, this customer, was acting on their behalf in chasing down, because ultimately who would benefit if these kids were caught and paid their $60 food bill, right? So that was the argument. And the other thing that the case tells us is that the individual, the customer, couldn't be found, right? Gone. So it's not as if they had this, the person who actually perhaps caused the crash to go after. He's gone. He's out of the picture, right? But this is sort of an interesting case, isn't it, right? Is the restaurant liable? What does the court say? Right. Now, sad situation. You want somebody, obviously the kids were being kids and they did something that they shouldn't have done, but nobody should have gotten injured here. They did. It was serious injuries. And, you're suing a company, And obviously, the company does expect to get paid for the food that it provides. But the court sort of said, well, look, everything happened very quickly, right? The manager never said, go get him or anything. The guy acted, the other customer acted on his own sense of vigilante kind of justice, caused this to happen. But you can't possibly say that there was a direction, even if it was implied or indicated in some way, that it was, the employee of Chile who was, acting on behalf of Chile if they're going to collect a bill or a check from a customer, but that they didn't authorize this. It just happened. And what they were really, the plaintiffs are sort of pointing to is, well, what about the fact that during this high-speed chase, the guy called and said, call the police or something like that. What about that? And then based on that, they actually did call the police. The court said, well, that doesn't show a principal-agent relationship. Sure, I mean, the restaurant is more than likely going to call the police in this instance. But this notion that they somehow authorized the high-speed car chase or going after these kids simply does not make any sense. So, this was not a agent of Chile's in any shape or form, right? So, I mean, the reasoning of the court does make sense. The facts support that reasoning. It's still a sad outcome, but we're really looking at it from a principal-agent relationship, and there just isn't one, that you can expect the corporation to pay out on this kind of a negligence claim. Powers of attorney. Most of people don't even wait until now. They always say, well, wait, what about a power of attorney? And that is a classic principal-agent. Really, it's not the only type, but it is a classic form. Can you hold off? I will get to respondeat superior. It means in Latin, let the master answer or something like that. But we'll get to that in just a second. All right, so a power of attorney is basically an agreement, and it's an express agency agreement that is designed to give the agent the power to do certain things for a principal, and essentially it is to act on legal documents, right? Has anyone here ever given a power of attorney? Ever gotten a power of attorney? Do you mind if I ask when and how?
I give power of attorney to my brother.
Okay. To do?
Do whatever he.
Okay.
To take care of my business.
Fair enough. And that's, it's usually for financial transactions,
Yes.
right? And it doesn't have to be to a family member, but it often is, right? And it's oftentimes, you think about, maybe someone going on a tour of duty outside the country, right? They're not going to be, you want somebody to handle your financial affairs, somebody going for surgery, somebody maybe just even being more fun, going on a sabbatical to Australia, going backpacking, no cell phone, no nothing. You want somebody to handle your affairs, right? So it could be any number of things, and sometimes powers of attorney are very general, broad powers on an agent to act in any matters on the principal's behalf. In giving a power of attorney to your brother, did you expect your brother to sell your business and pocket the money or anything like that?
No.
What were you expecting? I'm not disparaging your brother. I'm just trying to make a point here. What did you expect your brother to do?
Just to act as though I'm the one who's transacting the business.
Maybe deposit checks on your behalf, maybe.
Pay off the bills that need to be paid off.
Certainly. Yeah, it's really to do the legal things in your best interest as a fiduciary that, he's doing what you would do if you were here, to act reasonably and so on and so forth, right? And that's what someone granted a power of attorney is expected to do, to act on behalf of the principal, right? So power of attorney can be general, or a power of attorney can be a very special power of attorney, meaning to only act in a specified manner, right? I only authorize you to do X, not Y and Z, right? That's specific versus a very broad authority, again, to act on somebody else's behalf. Have to be in writing. A lot of states require it actually to be notarized and so on and so forth. All right, this is an employment law case, and this brings into I'm trying to see if the slides have respondeat superior or vicarious liability. We'll get to it, and maybe I'll explain it as we talk about this case. This is the Matthews case out of North Carolina. involved a grocery store. What happened? I'm looking for volunteers that I have not heard from. So far, I'm seeing only volunteers that I have heard from. Others? Since you asked me about respondeat superior, I'll let you do that one. I don't think this case was very well explained. I had to read it 3 times as to what happened. Yeah, yeah, was not, here's what we're supposed to infer. You have to. So yes, you're absolutely right. An employee, checkout cashier at a a grocery store chain, finishes her shift. They stand a lot, hard job, you're standing all day, you're just sort of clocking out. Before you go in your car, you say, let me just go to the bathroom, all right? So they're off duty now. They go to the bathroom that's available to customers, and they go in as well. The inference here is that when they opened the door, they did it quickly, they hit somebody. That's what you're supposed, I know it's badly written, but that's really what happened. And finds the poor person on the floor, call 911, person gets medical attention, person sues. Yeah, okay, so do you want to finish what happens here? So the question is Hall, who is the employee, acting within the scope of her employment at the time of the incident, because guess who they're suing? Now, this was not premeditated. This was an accident. And when there's a legal accident, the theory of liability is negligence, right? So the store and the employee are being sued for negligence. Now, usually when someone sues, they're looking for monetary damages, and the person that they're going to get monetary damages most likely from are the deeper pockets. So the question really is the store responsible for this accident? If really, indeed, the cause was not a slippery floor or anything, but the fact that this door was negligently opened, caused the head injury, caused the employee to fall on the floor. Don't think so, and neither did the court. And it came down to scope of employment, right? Because, and this is where respondeat superior and the concept of vicarious liability come in. Because the common law, the courts have said, look, if you're going to have a relationship where someone's acting on your behalf, and if that individual, during the course of their employment, for example, causes an injury, even in negligence, it becomes the responsibility at times of the party employing them, respondeat superior, let the master answer. This is old master. I mean, and it's also sort of known as vicarious liability, right? Vicarious through someone else, liability. So the employer inheriting the liability because of acts done by the employee, even though the employer not at fault, but still legally responsible, right? And we'll see this concept over and over again in the agency chapters and when we talk about employment law. And a lot of people say that's not fair, right? If I'm running a business, why am I responsible for negligent acts of my employees? And the answer is, again, the law is not black or white. The law is sort of trying to balance the interests of so many competing parties and saying who is in a better position vis-a-vis a third party to absorb the liability, and the notion that, again, companies, businesses can purchase insurance for that, right? A third party shouldn't have to be injured, accidentally or not, if they were just in a public bathroom, right? So, okay, so assuming that respondeat superior and vicarious liability apply, the first question is, was this employee even an employee when she went to the bathroom? Was this within the scope of employment? And again, everything comes down to the facts. And the facts of this case were, she'd clocked out. She could have been anyone. And, if you're going to hold someone liable based on employment obligation, you're not going to be able to do it. Could the customer still be successful just based on the fact that they were injured, on the premises of the store? Perhaps, possibly, right? But not based on this employee acting on behalf of the employer, because the employer was no longer the employer, right? I mean, when somebody has an 8 to 5 shift and at 5:15 they go to the bathroom, not an employee. Okay, it's a very sort of narrow set of facts, but the narrow holding of the case does make sense. And the book sort of describes another example. For instance, what if you hire a salesman, right? And the salesman is driving around on your behalf to sell products for you, right? And in the course of their day, they need to eat, right? So they stop off at a restaurant, and while they're in the restaurant, they wind up hitting somebody and injuring them. Is that scope of employment? It gets a little bit more murky. It perhaps could be. It's not as clear as that. Well, you say, but that sounds like a lunch hour. Yeah, but do more sort of senior level employees not necessarily have a concept of a lunch hour? They eat when they can and so on and so forth, and driving around and taking a little is perhaps still within the scope of their employment. So I'm not saying that these are black and white cases, but there is a bigger argument that this perhaps was scope of employment, and a case of vicarious liability where it might be the employer that may have to pay some of the claims, even though the liability, the fault is not with them, but they inherit that fault simply because of this relationship, employer-employee, and perhaps even a principal-agent relationship. So much more on that as we continue to talk this through. Let me sort of go through these couple of quick slides, and then we will take a break. I think we're definitely coming up on a break. Let's talk a little bit about agency relationships and how they're formed. Express versus implied. Well, if someone wants to have someone act on their behalf, they're going to tell them. They might even have to write it down. Those would be express. Authority is expressly given to the agent by the principal, such that the principal and third parties are bound to the contract. Anything that the agent does on their behalf, the principal is liable for. That authority could also be implied. Sometimes things are not spelled out, but you could assume, based on the broad authority, that it is understood, if you will, right? That is also a way in which agency relationships are formed. They're implied from the circumstances. Another way is by ratification, and ratification means to ratify is to approve, right? So ratification is, well, I authorized my agent to buy property for me up to $1 million. They went out and actually bought a property that was $1.1 million, but boy, it hit every wish list that I had. And I sort of say, well, technically, I didn't authorize this, but I am so glad. What's another $100,000? Chump change. I agree, right? I'm ratifying. And so an agency could also be formed after the fact by agreeing to something that was technically outside of the agency relationship. So again, different ways in which an agent can bind a principal. What else? Apparent agency. Apparent. I know this term sounds kind of alike. Apparent agency, don't worry, I'm not testing you. I'm just giving you an example of an apparent agency. Apparent is to give someone the appearance, what it would seem like to someone else. And the book had an excellent example. This is created when a principal leads a third party to believe that the agent has authority. And what if someone is interviewing for a position, a job, and the manager takes around that person during their job interview and introduces them to some of their customers and says, Joe here is our newest salesperson. You'll really enjoy working with him, right? They haven't hired him yet, but they're sort of just building him up. And they do a couple of background checks and they find out Joe is not the right fit. They never hire Joe, okay? Joe gets mad, gets angry for not getting the job, goes out and makes a contract with one of these people. They're acting, they don't have the authority. They're not the lawful agent. But here's the problem. The principal gave the appearance to a third party, didn't they? And it's a far out kind of set of facts. In that case, a principal creating that illusion actually gives a third party the belief, the reasonable understanding that this person can bind the principal, right? So that's when an apparent agency can happen. It's not often, but it is possible. An incidental agency, right? They start to look alike. Express, implied are the typical ones. Ratification, apparent, and incidental are less typical. What is an incidental agency? Authority that is implied to act beyond express agency powers to take all actions reasonably necessary to protect the principal's property and rights. Okay. Incidental to something. All right, let's say, again, I keep coming back to selling a house, selling a piece of property, right? And maybe it's sort of this power of attorney kind of thing. I gave someone a power of attorney to show my house to see if they can get a buyer while I'm out of the country. Okay? And that's what they're doing. One day they come in to check on the house and they find out, cold weather, a pipe burst. There's water damage. If they don't contain it now, it's going to be, they can't reach me. I'm backpacking in Australia. What do? They act as a reasonable person would. They go outside of their agency power. They hire a plumber. They incur a $5,000 bill, and they save further damage from happening. The question is the principal bound to pay that plumbing bill of $5,000? Did the agent act on their behalf when the agent was only hired to find a buyer? That is an example of incidental authority. It's incidental to what you were designed to do. It's implied that you were going to safeguard the property, and the fact that you had to pay this plumbing bill and hire a plumber means that that was incidental to your duty. It is a type of a proper agency relationship. Okay? These are all ways in which an agency is formed, understanding that the obvious way is expressed and implied from the circumstances, but there are some of these other ways in which a lawful agency relationship might be created. Okay? Let's stop there. Let's take about a 10-minute break. We'll come back. We don't have that much left to go. Let me quickly take attendance. Anastasia? So now that we've talked a bit about who a principal is, what an agent is, what are the lawful things that an agent can do for a principal, a little bit about how principal-agent relationship or agency relationships are formed, let's now talk about what are the obligations of the two parties. What are the principal's duties? What are the agent's duties? Well, here's sort of a little idea of what these duties are. Duty to reimburse, duty to cooperate, duty to compensate, duty to indemnify. All of these duties are what the principal owes to an agent. Let's look at what they mean. And they basically, there's no science to all of this. It's pretty obvious and basic. Principal's duty to compensate sort of works with the notion that an agent is doing things to benefit the principal, right? That means that the principal is going to pay an agreed upon amount to an agent. When you talk about different types of agencies, not every agency relationship leads to a principal having to pay an agent. For example, the gentleman here that talked about appointing his brother as his agent under power of attorney was presumably not paying the brother, but oftentimes you are appointing somebody for a purpose and you're agreeing to compensate them. It's for a business purpose, right? So a duty that a principal owes to an agent to pay an agreed upon amount, maybe some other compensation. I mean, if we're talking about an employer-employee relationship, we're also talking about, wages or other compensation that flow from that. If there is some understanding that there will be payment, but there's no agreement as to the amount of payment, then, the law will step in and say that it's understood that the agent would have gotten paid and it would be the customary amount for that fee in that industry. For example, I gave an example just before the break about the incidental agency, right? You might say, well, nowhere in that contract did it say what the homeowner was going to pay the agent if the pipe burst. Where do you come up with that? Well, you come up with that based on reasonableness. Well, what did the agent pay? Did the agent have to take time off from work to be there while the plumber worked and so on, right? So all of that is folded into a duty to compensate your agent when they are doing things in the principal's interest to advance their purpose, right? So that's sort of the duty to compensate. And duty to reimburse is sort of related to that, again, to the extent that the agent incurs expenses. And those expenses are not their expenses, it's really expenses to benefit the principal acting within the scope of the agency. Well, yes, in that case, it is the principal's obligation to pay or reimburse the agent for those monies that are spent. What else? The duty to indemnify. Indemnify is this notion of making whole, right? What if the agent did something that actually caused them to suffer a loss, financial loss, and they were really acting on behalf of the principal? And when might that happen? Well, same thing. It's sort of the example that I just gave a minute ago. I keep coming back to the pipe bursting. Yes, they pay the plumber's bills, but they suffered a loss of being there, not having, missing a day's work, not doing their own business, a half a day that was wasted being on the agent's premises while the pipes were being fixed, right? Are losses that the agent suffered, financial losses that were related to the scope of the agency. There is a duty to indemnify, a duty to make whole, right? And all of this is sort of contemplated, yes? To make whole, okay, sorry, indemnify means to make whole, W-H-O-L-E, it's just a phrase that means that I will compensate you, I will make you, I will, how do I, to put you back in status quo. That's what it means to make whole. It's just a term of art. Sorry. Duty to cooperate, I mean, again, if we're, asking somebody to act on our behalf, the principal has a legal obligation to assist the agent with whatever it is that they've assigned them to do. If I want to hire somebody to show my house, it's my obligation to keep the house in a good enough condition so someone doesn't get injured, to provide keys, to keep, have a fire extinguisher, whatever the case might be. These are sort of common sense things that a principal owes their agent if they're going to ask somebody to act on their behalf. All right, what's the flip side? What does an agent owe a principal? Duty to account, duty to perform, duty to notify. I mean, the names kind of tell us where this is heading, right? What does it mean to perform? Again, why is someone engaging somebody to act on their behalf? They want them to do something for them, right? So there is inherent in that agency relationship to perform the lawful duties expressed in, look at the word, in the contract, right? What is an agency if not a contract, right? It is. An agency is, whether it's written, whether it's oral, whether it's expressed, whether it's implied, or whatever it is, it's basically one party agreeing to act on behalf of the other party. And contractually, the only way that you perform on a contract is that you do what you're supposed to do under that contract, meeting the standards of reasonable care, reasonable skill, and diligence implicit in all contracts. Do what a reasonable person would do. Because guess what? If an agent doesn't do it or goes outside of the parameters of that agency relationship, essentially, they breached a contract, right? So it is a legal relationship where the agent owes a duty to perform lawfully under the terms of an agency relationship. And implicit in this is an obligation on the agent's part to keep the principal in the loop. That's a duty to notify, right? Notify of what? Of every small little detail? Maybe not. You have to exercise some judgment here and so on, of important information concerning the agency. Why? Because vis-a-vis third parties, just because the principal has appointed an agent doesn't mean that the principal is not liable, right? So the information that an agent has is attributed back to the principal. The law is going to say, well, if your agent knew it, you should have known it, right? So if I'm off somewhere and somebody else is managing my property and the state officials come in and they find some violation and they ask me to correct it, my agent is acting on my behalf. They take the information. Well, what is their obligation? If I have 60 days to remedy something, it's either their responsibility to tell me right? And if they cannot tell me because, again, I'm backpacking in Australia somewhere, to use your incidental authority and fix it, right? Because that information is important, significant information that, again, if I'm hiring someone to act on my behalf, that I expect them to act as a reasonable person, to do what would be reasonable under those circumstances, to either inform or to act on that duty. And to account, and this is basically a relationship of trust, loyalty, fiduciary duty that basically says that if monies are involved, where the agent is handling the finances of a principal, that they're acting within the agency relationship and they're accounting for that money. And by that I mean that they keep good records, keep good transactions. They don't commingle. And the word commingle means that they don't take their money and my money and put it all together, right? It is a separate pot. You keep a separate account for the principal. You only use the principal's property as specified in that agency relationship. You basically account for the monies that are entrusted to you. And that's obvious, but it's worth highlighting that the agent is acting on behalf of the principal. Even if they're entrusted with monies, it's, again, I come back to you in asking your brother to safeguard and act on your behalf on part of the business. There is a duty to account, right? Because those monies belong to the principal. Is an agency relationship indefinite? Could be. Does it end at some point? Usually. How does it end? Well, it's like a contract. It could end by mutual consensus of the parties. I no longer need you to act on my behalf, or you've accomplished what you've done already. So yeah, our mutual agreement terminates an agency. It's a contract. It's a voluntary agreement. Maybe it was only for a period of time. I hired somebody for a period of 3 months, 6 months to see if they can find me a property or sell my house. If they didn't or they couldn't, maybe I'll find someone else. Maybe I'll keep the property, whatever it is, a period of time. When a specified purpose is achieved. I mean, if the purpose of our arrangement was for you to find me a piece of property, you did, that's it. You're no longer my agent. We've already done what it is that the agency relationship was formed for, or some other event. Right? If we said that, my going into another line of business will end the relationship, well, then that's specified and it's understood. Right? These are voluntary agreements, and one can write into it any termination condition that is lawful and agreed upon. Typically, it is a good idea, whether oral or written, that you tell somebody that the relationship is terminated, right? A notice of termination doesn't have to be formal. There are other things that could lead to a termination, such as unusual change in circumstances, leads the agent to believe that the principal's original instructions should no longer be valid. And you can think of different scenarios, right? I mean, what if there is a sharp increase in prices? It is clear that the market has gone way up than what you were authorized to sell the property for, right? What would a reasonable agent do? A reasonable agent might say, hey, wait a minute, maybe the original instructions to sell this property for $1 million no longer make sense when, property values have gone up. Maybe I need, again, what would a reasonable person do? Are these changes in circumstances unusual enough that a reasonable person in that position would question their authority? Termination by impossibility of performance, the loss or destruction of the subject matter, right? I mean, you can't act on something if it no longer exists, right? So a change in the law. It was lawful to do X, Y, and Z. All of a sudden, the law changed, and you cannot sell X, Y, and Z. The agency relationship terminates because of impossibility, right? So again, this is not rocket science. This is essentially either the parties themselves end a relationship, or circumstances or other events out of the control of the parties ends that agency relationship. So it's just like a contract. It's just like, an agency relationship is essentially a type of contract. And yes, it is possible that by sheer operation of law, an agency relationship can terminate. One of the parties is no longer alive. Kind of hard to, I guess that sentence doesn't even need to be finished. It would be impossible. right? The mental incapacity of the principal or agent. We saw bankruptcy halts things, right? Just because you have an agency relationship where someone has the authority to sell something on behalf of the principal, but the principal is in bankruptcy, and now there's automatic stay. There's a legal reason why that agency relationship has been terminated, and the last one is sort of silly, but it's still, something that is, in the law. Could you have a wrongful termination? Is it possible that a principal could perhaps end a agency relationship before it was time? What if you put into a contract or an agency relationship that you, my agent, have a 6-month contract, a 6-month window within which to do something, and I decide that I can get someone better in 4 months? Can I end that relationship? It's a contract. Sure, I can, but are there legal consequences to that? Yeah, it's a breach of agreement. It's a breach of contract. So yeah, yes, I always have the power to do it. I may not have the legal right to do it, and doing so could lead to damages, right? My agent could come and say, look, I had an extra 2 months. I could have made a commission. I'm suing you for ending the contract before the stated purpose, or I didn't do anything wrong. You just found someone better. Well, too bad. You owe me a commission.